Hey all, welcome to today's video. Today we're taking a look at a DMCA failure, specifically Cox Cable's $25 million mistake. So with the DMCA failure, we're talking about a situation where a company failed to follow the compliance process detailed in the DMCA and waived the immunity provided by the law. So my name is Rick Chapo. I'm with DMCAagentservice.com. We provide third-party agent services to websites and app owners who want to comply with the law, but don't want to list their personal information publicly when they designate an agent. So in this case, we're taking a look at Cox Cable. So this was a case that kind of shook the online industry quite a bit. What happened was in 2014, Cox was sued by BMG, a music publisher, and the music publisher alleged that Cox was jointly liable with its users for copyright infringement. And Cox responded, no, we're not, because we have immunity under the DMCA. And so just to review real quick, the DMCA has a provision known as 512C, Section 512C, that says that an internet service provider cannot be held liable for monetary damages for copyright infringement based on content uploaded by users. So let's use an example. This video. I'm creating it, and you may be viewing it, well, wherever you're viewing it, it's at least uploaded to YouTube. That's where it started. And when I uploaded it to YouTube, if I included something in this video that would constitute infringement, such as this little character to the right, if I'm using that without the consent of the person who originally created it, then I can be sued for copyright infringement. But what about YouTube? Well, the answer is under the DMCA, Section 512, that YouTube could not be sued. They are immune from monetary damages for anything that I upload that would constitute an infringement. Now, this immunity comes with a price. You must follow a particular compliance process. And a part of that compliance process is the establishment and enforcement of what's called a repeat infringer policy. So this policy basically says that if a user of your website, app, or service gets X number of DMCA complaints within a specific period of time, then their account must be terminated. It's just that simple. And so why do we have this clause? Well, the drafters of the law were trying to deal with a situation where perhaps you've invested a lot of time and money and effort into developing content. Somebody takes your content and let's say they post it to Facebook, and you serve a takedown notice. And so they receive a note from Facebook that this has occurred. They come back to your site, they grab another piece of content and post it. And they just keep doing it. And so you end up with this never-ending process, and it all becomes rather ridiculous pretty quickly. And so the repeat infringer policy is designed to essentially prevent serial infringers from getting away with that kind of conduct. And so you see some platforms, this becomes a big issue. We get calls all the time from people who have lost their Tumblr account, for instance, because people seem to not really understand what these complaints are and that there is a repeat infringer policy out there. And if you have an Instagram account or whatever it is, and you've developed a ton of followers over a lot of time, and suddenly your account is closed, well, that might be a bad day. So what happened with Cox Cable? So Cox said, no, we have a repeat infringer policy and we follow it, and therefore our immunity is in place and you can't sue us. And so the lawsuit went forward and discovery was undertaken. And at that point, the parties exchanged information, including documents. And as part of discovery these days, you always ask for email messages from the other party. And so Cox dutifully provided that information. And, as Scooby-Doo would say, ruh-roh, the evidence was ugly. In fact, if you were to view the merits of Cox's case at that point, it would have sounded something like, the emails were not good. Specifically, the court actually pointed out some of the more damning ones. Let's see, there was an internal email from one Cox executive to another that said, quote, if a customer is terminated for DMCA, you are able to reactivate them. This is to be an unwritten semi-policy. So not only does the policy violate the DMCA, but it would appear the executive knows that this is going to be the case because he says unwritten semi-policy. Wink, wink. Another email summarized Cox's practice. More succinctly, it read, quote, DMCA equals reactivate, end quote. So, as you can imagine, plaintiff made these Exhibit 1 and 1A in the hearing over whether Cox had waived the safe harbor immunity provisions. And based on this evidence, it is no surprise that the court ruled that, in fact, Cox had waived the immunity. And the case went forward, and eventually Cox was hit with a judgment of $25 million. A lot of smackaroonies, and on top of that was hit with court costs of $8.5 million. So by failing to follow its repeat infringer policy, the company basically exposed itself to a $33 million judgment. Now, the judgment was appealed and went up on appellate court, and the appellate court played around with the case a little bit, but they did not reestablish the immunity. They said, yes, Cox has waived this. And ultimately, the case was settled, and from the statements surrounding the settlement, it would appear that BMG recovered a very large percentage of that judgment because they called it a quote-unquote substantial amount. And usually if you have a settlement where the parties one party isn't at a huge disadvantage, it will instead say things like the defendant does not admit liability, despite cutting this large check, apparently for charitable reasons, who knows. And that was not the case here. And so it would appear that, Cox really had to bite the bullet on this one. So if you own a website or an app, what can you take from this? Well, it's not enough just to designate a DMCA agent, slap policy up on your platform. You need to actually understand the infringement process or compliance process and follow it. It's not that hard. It really isn't. There are articles online. You can go to our site at dmcaagentservice.com and see a guideline. There's a book called the DMCA Handbook. I believe version 2 is out now. It's a bit expensive, maybe $80. But $80 is a lot less than $25 million. And so, you may want to give that a read. But nonetheless, this is a situation where the DMCA protection failed, not because of a problem with the DMCA, but because a company didn't follow it. And you would think a company as large as cable company, Cox Cable, that wouldn't be the case. So anyways, there you go. So again, if you need a DMCA agent for your website or app, feel free to contact us at dmcaagentservice.com. If you have comments or questions about this video, just post them below. I'll be happy to answer them. We'll be posting DMCA videos all the time, so feel free to subscribe to our channel. And otherwise, thanks for watching. Have yourself a good one.